Hey everyone, it's Professor Morris checking back in with you to talk about the case I'd asked you to review for class exercise 2. This case is a little bit complicated, so what I wanted to do was kind of walk you through it, brief it myself, give you some idea of what you're looking at. And of course, we're talking about L.E.B versus D.D.C. What I have up on the screen is Westlaw, by the way. Here's the story with Westlaw. I know I've referenced it a couple of times in the assignments, asking if you have Westlaw access, you can download it or try downloading it. TCC has a Westlaw license. The license is for students in the paralegal program. I am working with the TCC library right now as we speak, trying to get you access to Westlaw, all of you. I don't know if I'll be successful. A lot of it depends on what the library decides to do. But the bottom line is I'm working on that, and I'm hopeful that we can eventually get this done. And if you're in the paralegal program, and I know some of you have taken my family law class and are returned students, if you continue on working with me, I may have Westlaw access for you in the future as well. I'm working on that. Bear with me. And by the way, once I do have that access code, I will start working with all of you on how Westlaw works and how to make it work for you. It's an excellent research tool. It's one of the 2 primary research engines and platforms that law firms use. And I think knowing how to use Westlaw will make you more employable. That was the argument I made to the college. I'm hopeful that they will get off their you-know-whats to get me codes so that we can get you Westlaw access. With all of that said, let's talk about this case. This is L.E.B versus D.D.C. This is a family law case. Now, I know this isn't family law. This isn't a family law class. I get that. And we will be looking at other types of cases in the civil procedure realm, because this is primarily a civil procedure course. And so any field of law that involves civil procedure, whether it's personal injury, contract disputes, car accidents, family law, defamation or slander, anything that basically isn't criminal or bankruptcy is considered a civil case and falls under the purview of the rules of civil procedure, which again, we will be discussing in more detail as we continue on with the course. I know things are kind of moving slowly right now. That is on purpose. I know a lot of you already know a lot of the stuff that I'm assigning you. Again, this is review work. You cannot do this stuff enough in order to master it. In fact, once you graduate and move on to bigger and better things, either at a 4-year college or at a law firm in a paralegal office, you will continue the learning process. I promise you that. I've been out of law school. I graduated from law school in 2006. I am still learning new things about the law and how the law works. That's one of the great things about this field, the legal profession, is you are constantly learning new things. It does not get old unless you're in certain types of, if you're in like tax law or accounting, working for a CPA firm, that might be a little bit boring. But then again, for those of you who are math people, that may be your thing. You may find that exciting. And I certainly hope you do if that's something that you want to do. So let's get back to this case, L.E.B versus D.D.C. It is a family law case. It's a paternity case. And for those of you who aren't familiar with how paternity cases work, these are cases that involve individuals who are not married. Under Florida law, if you're married and you have a child, the child is presumed to be a product of the marriage, and therefore the husband is presumed legally to be the father. Now, that sometimes isn't always the case. We're not going to get into that right now, but I think you know what I'm talking about. This is not a divorce case or a child custody case. This is a paternity case where the actual parentage of the child is trying to be determined by the court. Now, when you read this case, you're going to notice that these 2 parties are in front of a magistrate. A magistrate has the same authority and power of a judge. And in fact, a come in, everybody, stands up, they wear a black robe, they carry a gavel. If you didn't know that they were a magistrate, you would basically think that they were a judge based off of how they operate their courtroom, as well as the cases they cover, and of course the fact that they are wearing a black robe and carrying a gavel, and everybody calls them Your Honor. Magistrates are not elected. That's the biggest difference. They are appointed by the chief judge of the circuit where the court is held, and also, and of course, the governor also gets involved in that. And so you can become a magistrate if you have a law degree and don't want to run for judge, but believe that you have the ability to be a judge. And magistrates are there to kind of help grease the wheels of the court system. Unfortunately, and I'm sure many of you are aware of this, the Florida court system is incredibly busy and packed with cases. And so to move these cases, there just aren't enough judges in the state. So magistrates are appointed, and again, they have the same power and authority as a judge. But when they render a ruling in a case, they issue a report, and that report then goes to a circuit court judge who signs it as a final order. And you can appeal that report. You can appeal it as these parties are appealing it if you don't like the outcome. And you can, again, these magistrates have the same power and authority as a normal judge. The other thing I wanted to kind of point out to you is the fact that these two individuals, their identities are basically hidden through the use of their initials rather than their names. And the reason is because this is a paternity case, and there is a minor child involved. And when there's a minor child involved, the privacy of that minor child is always at a top priority. And that means while the parentage of that child is being determined in court, they want to protect the child's identity by protecting the identity of the parents. And this is why you've got L.E.B versus D.D.C instead of, say, Jones versus Smith, and the use of their formal names in the case. So let's get to the actual case at hand. This is a case that I pulled for you for a number of reasons. The first is that it involves various steps in the civil procedure process that we're going to cover in this class. Primarily, the idea of an initial intake interview, which is what we're covering this week in our weekly lecture, as well as mediation and the basic trial level, and of course, the appellate level, things that we'll start covering next week and in the weeks to come when we start talking about the court system and the different tiers of courts and the different types of civil courts. So this is a case that involved, again, a paternity case where they're trying to determine the parentage of a child. And the father, when he first decided that he wanted to determine the parentage of the child, he filed a petition to determine paternity. The parties went in front of a magistrate, and it was at that point that the parties were then required to go to mediation. What is mediation? Mediation is essentially a negotiation phase of the case process, and it is required in most civil cases here in the state of Florida. Why is mediation required? Well, a number of reasons. The first being the fact that, again, needing to move cases along, to keep cases moving forward is important. And so you want to, if you can settle cases out of court without having to go to trial, because to get even in front of a magistrate or an actual circuit court judge can sometimes take months. In fact, the case that we're looking at had been pending for over a year before it was finally adjudged at the appellate level. So this is a situation where mediation can sometimes be a really valuable tool for parties who just want to get the case over with and kind of move on with their lives. And so what happened is the father decided that he didn't want to pay for an attorney. He went to his local legal aid foundation in the district where he was located. He filled out an application. He sat down with an intake interview paralegal, at the legal aid office, and he explained his case to them, explained that, he didn't know really if he was the father or not of this child. And then what happened is the Legal Aid Foundation, where he applied for free legal services, turned him down. They turned him down based on income. They looked at his income, because you have to provide a bunch of income disclosure when you apply for legal aid. And they determined that he made too much money. And the mother, on the other hand, did successfully get a financial aid attorney to represent him, her, or a legal aid attorney to represent her, because her income was low enough. And so what happened is, after the husband or the father was turned down, they get to mediation, and the father's like, "Hey, where'd you get this free legal aid attorney?" And the mother's like, "Hey, I qualified because my income was low enough." He did not qualify because his income was too high. And so what he does is, when he gets in front of the magistrate, one of the first things he decides to do, almost a year later after the case was filed, is he issues what's called an ore tennis motion. An ore tennis is another fancy Latin term that basically means an oral motion. Instead of a written motion that you file with the clerk and try to argue in front of a magistrate or a judge, an ore tennis motion is when you basically show up in court for your hearing, for your trial date, and you verbally make a motion to the court. And in this case, the father's ore tennis motion was essentially to get the legal aid attorney removed and disqualified from the wife, so that if the husband wasn't going to get a legal aid attorney, then darn it, that mother isn't going to get a legal aid attorney either. And so through this ore tennis motion, the father, the putative father in this case, L.E.B, decided that he, or D.D.C, was going to file this ore tennis motion and try and get the financial aid attorney for the wife, or for the mother, disqualified. That originally was successful, and both parties were pro se. Pro se is just simply another fancy legal term for representing oneself or on behalf of oneself. And the father was successful. There was an appeal, and this went to the District Court of Appeal. And it was there where the District Court of Appeal basically said, "Wait a minute, Mr. Father, Mr. Putative Father here, we don't really think that your ore tennis motion was timely. You had notice of over a year that the mother had this legal aid attorney, and you did nothing. You didn't file anything. You didn't file any motions with the court. You just kind of waited until you got a chance to get in front of a magistrate, and then you tried to get the mother's attorney disqualified from the case." And the appellate court basically said, "No, we're not going to do that." The mother in this case had a right to counsel, that she basically, the fact that she had a legal aid attorney didn't prejudice the father in this case, that the motion was untimely, and that basically there were no grounds for it. And so the mother got to keep her legal aid attorney. The father had to remain pro se, and the case was remanded back to the lower court to be decided with regards to the parentage of the child. So overall, this was just kind of a procedural case, but it was a case that involved mediation. It was a case that involved a verbal motion. It was a case that involved the intake interview, where the father basically, again, tried to claim that because he filled out this application and sat down with a legal aid attorney, that he was therefore entitled to representation, and that he was a prospective client. And that's just not true. But also, this case is really cool with regards to the footnote, which talks about the confidentiality of intake interviews. And this is where I'm going with this. And again, I promise I'm gonna end this lecture in about a minute or two. So hang in there. And that is this fact that when a prospective client shows up at a law firm, and this includes a legal aid office as well, that as soon as that prospective client sits down and starts to explain their case to a paralegal or a legal secretary, or in sometimes even the attorney himself or herself, that may be handling the case. Sometimes some attorneys really like to do the intake interviews themselves because they want to get involved with the case right away and kind of get a feel for the case and for the client as well. And so this was a situation where the court basically said, look, we need to be very clear on how intake interviews work and the fact that when there is an intake interview, that is a prospective client under the rules of professional conduct operated by and enforced by the Florida Bar. And if some of you don't already know, I work for the Florida Bar. So I've actually had to enforce some of these rules as an investigator and not as a bar counsel, but as an investigator. And so the bottom line is that you have to be knowledgeable that when you are meeting with a client, even if that client doesn't end up hiring your firm, even if that client doesn't hire your boss, your law firm or your attorney to represent them, that anything they tell you during that intake interview is confidential. You cannot share that information with anybody. The bubble of confidentiality that I mentioned in the written lecture starts to apply immediately. And that applies if you never even see that person again. If that person comes in, tells you about their case, explains everything, and then says, once they hear how much the retainer is going to be, or maybe they don't like the attorney, or maybe they're just kind of shopping around. The bottom line is it doesn't matter. The bottom line is that when you meet with a client for an intake interview of any type, whether it's a prospective client interview or an interview where they've already signed a fee agreement and they're ready to rock and roll and move forward with their case. The bottom line is all of that information is confidential. The confidentiality bubble is created the moment that client walks in the door. And by the way, that also applies to the fact that that client walked through the front door. In other words, you cannot disclose to anybody that that person visited your office seeking legal advice, seeking legal counsel. So these are the bubble of confidentiality is hugely important. And the reason I say this is because, again, working for the Florida Bar, I've had to work on cases where confidentiality issues were a problem that somebody in the law firm, whether it was the attorney or an agent for the attorney, i.e. a paralegal or a legal secretary, had violated that bubble of confidentiality. They disclosed facts about the case, or they had used facts about the client, the prospective client, against them when they represented someone else against that particular client. And that is a rule violation. So you've got to be super careful when you plan intake interviews. You want to make sure that you protect those documents when they fill out an application. If they sign a fee agreement, that also goes into their file. All of that is confidential and has to be kept secret. This is especially important in family law cases and paternity cases where the client's identities and the identity of a prospective child have to be protected as well. So make sure that you protect those documents, make sure that you protect the person's confidentiality, even if they don't hire you as their counsel for their case, and protect yourself, protect your law firm, and be smart when it comes to the rules of confidentiality. So that is the case that I wanted you to look at for class assignment or class exercise number 2. I asked you some questions with regards to that. I think I answered those questions in this lecture. I hope it's helpful. If you still have questions, you folks know, please email me, touch base with me, let me know what I can do to help you. I don't want anyone to feel lost. I don't want anyone to feel left behind. And I'll do the best I can to guide you through all of this. So thanks for listening. I'm sorry this was kind of a rambling lecture, but I'm going without notes and briefing this from memory. And so I think I covered everything. If I didn't, I'll certainly put in a written supplement to help you with that. But have a great day, everybody. Thanks again for listening, and we'll talk again soon.